Good afternoon, everyone. This meeting is called to order. Mr. Trowman, is anyone signed up for public comments?
Yes, sir.
Thank you so much. Good afternoon, Ms. Gonzalez.
Good morning, good afternoon.
It is afternoon. We have no cases to reconsider under agenda item 3. Is that correct?
That is correct.
Let's look at tax liability cases under agenda item 4. I believe we have 2
That
tax
is
cases
correct.
on docket 36. Is that correct?
That is correct. We have 2. The first one is TD 200570320. Commissioner Dimerson,
I agree with staff recommendation.
Commissioner Alvarez,
Ms. Gonzalez, nice to have you today. I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
Thank you. The next one is TD 210190621. Commissioner Dimerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Chairman Daniel.
Agree with staff recommendation.
Thank you.
So we have no fair housing cases under agenda item 5.
That is correct. There are no cases pulled for agenda item 5. However, you should have received the short form dissent list for the wage claim cases.
Which will be on agenda item 6. So no wage claim cases on docket 36 pulled for additional
Nope.
discussion.
My apologies.
No worries. I think we have the list right here, gentlemen. I move we accept staff recommendations on the main wage claim cases on docket 36.
Chairman, I second the motion except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 36.
And I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 36.
Motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 36. Please proceed when you're ready.
Case number 2643788, Commissioner Alvarez.
The decision should be modified. The claimant provided sworn testimony that he did not receive the hearing notice. The claimant established good cause for his non-appearance. With regard to the job separation, the employer presented only hearsay that the claimant refused to perform a task as instructed. The claimant provided sworn testimony that he merely requested the proper PPE to perform a task in the industrial freezer. The employer did not contradict the claimant's testimony that he lacked PPE to satisfy, PPE to safely perform the task. The claimant's sworn testimony carries greater weight than the hearsay provided by the employer. The evidence fails to establish misconduct connected with the work. Modify the AT good cause for the claimant's non-appearance, no misconduct, chargeback, void, adequate response. If my fellow commissioners find the record to be insufficient, I would also agree to a rehear to further develop the record on the PPE issue.
We should modify the appeal tribunal decision. As to the good cause issue, I do not dispute the appeal tribunal's finding that the claimant had good cause for missing the first hearing. Regarding the separation, the claimant had received numerous warnings for his insubordination and poor job performance. On May 14, 2019, the claimant was provided a final written warning. The claimant was advised that another violation would result in termination of employment. On the last date of the claimant's employment, he refused to complete a task which, according to the employer, was a part of the claimant's job description. Since the claimant was aware of the potential consequences of insubordination and thereafter engaged in such prohibited conduct, the claimant's discharge constituted misconduct connected with work. Accordingly, we should modify the appeal tribunal decision. Claimant had good cause for missing the first AT hearing, misconduct, no chargeback, sever adequate response.
Modify the AT, claimant established good cause for AT1, no misconduct, chargeback, void, adequate response.
Short form dissent.
I have your short form dissent, Commissioner Dimerson.
Case number 2667080, Commissioner Alvarez.
The decision should be reversed. The claimant attended a safety meeting and was in without work for 2 weeks because there was no work at the time. As such, the claimant was laid off due to a lack of work and should be qualified for benefits. Reverse the AT, no misconduct, chargeback. In the alternative, the decision should be modified. No misconduct, no chargeback, disaster. The claimant was given permission to delay his proposed start date due to a death in the family. When he attempted to return to work, the site had been shut down due to the weather. This is supported by the claimant's testimony and text messages in evidence. The claimant was then unable to report to work because he contracted COVID-19. As such, the claimant was separated due to a disaster. Modify the AT, no misconduct, no chargeback, disaster.
We should affirm the appeal tribunal decision. The claimant's work separation was a result of job abandonment. The claimant informed his foreman that he would be away for a week due to the passing of his mother-in-law. During the week in question, the claimant assured his foreman that he would keep him informed about his intended date of return. That week, the claimant failed to contact or update the foreman about his date of return. Per commission president, the claimant leaving without providing the employer with a definite time of return constituted a voluntary quit without good cause connected with the work. As such, we should affirm the appeals tribunal decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent. And if I could also have a memo to UI to investigate whether the claimant qualifies for PUA benefits.
I have your short form dissent, and we will send a PUA memo to UA and iOS.
Thank you, Ms. Mendel.
Case number 2752966, Commissioner Alvarez.
The decision should be reversed. The claimant and her former coworker both confirmed that the employer had at least 4 full-time employees for 20 weeks in 2019 and 2020. 4 full-time employees working during the year and half that the claimant was employed is more than enough to establish liability under section 201.033 of the Act. The employer did not appear to offer testimony or evidence. The testimony offered by the tax department is hearsay based on the employer's statements and incomplete. The claimant is entitled to wage credits. Reverse the AT, the claimant's work constituted employment. She is entitled to wage credit of $20,000 in each quarter of her base period. 3, 2019, 4, 2019, 1, 2020, and 2, 2020.
The AT decision is supportable, although an additional hearing was held for the purposes of gathering all relevant evidence of employees working for the employer's nonprofit organization. That evidence was insufficient to show that there were at least 20 weeks in either 2019 or 2020 in which the employer had at least 4 employers working at the same time. There's thus a lack of evidence to show that the employer was a liable employer under Texas law. Since the employer was not a liable employer, the wages earned by the claimant from that organization cannot be used for her unemployment claim. Accordingly, we should affirm the AT decision. The claimant is not entitled to wage credits from the named employer.
Affirm the AT, claimant is not entitled to additional wages.
Short form dissent.
I have your short form dissent, Commissioner Alvarez.
Case number 2766166, Commissioner Alvarez.
Regarding the good cause, the claimant called in prior to the hearing, but was disconnected and unable to reach a TWC representative until after the hearing began. The claimant has good cause for his non-appearance. Regarding the timeliness, the claimant has provided clear and consistent testimony and numerous appeals, all stating he filed an appeal on November 10th of 2020 within the appeal period. In accordance with commission precedent, the claimant's clear, consistent, and uncontradicted testimony is sufficient to elevate his testimony to a level of credible and persuasive. As such, his appeals should be deemed timely and the case resubmitted for merits. Modify the AT, good cause, timely appeal, resubmit.
The appeal tribunal decision should be modified. I do not contest the good cause issue. As to the timeliness, the claimant filed his appeal beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules, and the claimant has not provided sufficient evidence of an earlier timely appeal. Accordingly, the claimant appeal should be dismissed as late, with the underlying decision left in full force and effect. We should therefore modify the AT decision. The claimant had good cause for his non-appearance, untimely claimant appeal, voluntary leaving, no chargeback, and correct the late appeal date in the AT decision.
Modify the AT, claimant established good cause for AT1, untimely claimant appeal, voluntary leaving, no chargeback. Correct the error in the AT decision.
Short form dissent.
I have your short form dissent, Commissioner Alvarez.
2802-747, Commissioner Alvarez.
The claimant was discharged for allegedly working beyond the employer's 8 hours per day limit. The claimant is the only party to provide firsthand testimony regarding her hours, and she testified she clocked out 2 minutes late because she was waiting in line at the employer time clock. The claimant corrected the first late clock out by working less the next day in accordance with the instructions she received. The claimant was unable to fix the second late clock out because she was discharged. Further, the claimant provided firsthand testimony that the employer's hours recorded for her final pay period were incorrect. The claimant has made numerous requests for the employer to provide time card information, which the employer chose not to provide. Additionally, even if we could find that the claimant worked unauthorized overtime, the employer has admitted they did not follow their progressive disciplinary policy. As the claimant has denied working the overtime hours, any late clock out was due to circumstances beyond her control, and the employer did not follow their policy. The claimant is entitled to benefits. Reverse the AT, no misconduct, chargeback, void, adequate response.
The appeal tribunal decision should be modified. The claimant was discharged for working unauthorized overtime. Per documentation and file documents, the claimant had previously received a final warning which notified her that she would be fired for any further deviation from company policies and procedure. Since the claimant worked unauthorized overtime in violation of the employer's policy, and since the claimant was previously provided with the final warning, she mismanaged her position of employment, which amounts to work-connected misconduct. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate response.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
I have your short form dissent, Commissioner Alvarez.
Case number 2823-218, Commissioner Dimerson.
This case should be remanded to the appeal tribunal. Here, the employer was a temporary help agency. The available record was unclear about the type of work that the claimant did for the employer. The appeal tribunal hearing was vague about whether the claimant was working a temporary assignment for the employer rather than working as a full-time staff at the employer's office. Since reporting requirements differed based on the type of work that the claimant did for the employer, we should remand the case to take testimony and develop the record about the claimant's job duties.
The AT decision in this case is not supportable. First of all, while the employer is supposedly a temporary help firm, there was no evidence of any policy requiring that the claimant to report for reassignment or that the claimant had been made aware of any such policy. While the claimant stated in his testimony that he did not pursue additional assignments because he did not feel it was his responsibility, this statement should not be interpreted as out of context. Specifically, since the claimant was never notified of the policy requiring him to report for additional work, he had no reason to know any such responsibility existed. Moreover, the claimant worked in the same job for 1.5 years. There is therefore no basis to conclude that the claimant worked in a temporary work or that section 207.045H of the Act applies. The claimant was involuntarily separated for financial reasons that did not constitute misconduct connected with the work. Reverse AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
I have your short form dissent, Commissioner Dimerson.
Case number 2823-316, Commissioner Dimerson.
We should reverse the appeal tribunal decision. In a fact-finding statement, the claimant provided when she first filed for her claim, she noted that the primary reason for acquitting was unfair treatment. She explained that not being promoted to the assistant manager position caused her to quit. Since the claimant provided this reason closer in time to the job separation and before being disqualified from benefits, this prior statement is more credible than her later testimony. As such, because the claimant quit due to not being promoted for personal reason, she quit without good cause connected with work. Accordingly, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response. In the alternative, if my fellow commissioners are not convinced, contrary to her fact-finding statement, The claimant's testimony indicates that she quit due to a shortage of PPE supplies early on during the pandemic. Since employers were struggling with PPE shortages at that time caused by the COVID-19 natural disaster, we could qualify the claimant for benefits and protect the employer's account from charge under disaster separation analysis. In that case, we would modify the AT decision: no voluntary leaving, no chargeback, separation caused by disaster.
Ms. Gonzalez, I would agree with Commissioner Demerson to modify no voluntary leaving, no chargeback disaster.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response.
Can I have the chairman's vote read back?
Yes, Commissioner Demerson, your primary vote was that the claimant had quit without work-connected good cause, no chargeback, adequate response. Is that correct?
That's correct.
And Chairman Daniel, that was your vote, correct?
Correct.
So therefore, that would be the primary vote when we have a majority vote.
Ms. Gonzalez, short form dissent.
Okay, all right. Thank you, Commissioner Alvarez. I have your short form dissent.
Case number 2827923, Commissioner Demerson.
We should modify the appeal tribunal decision. The claimant in this case was a type 1 diabetic. His medical condition led him to suffer from the effects of nausea and vomiting. Regarding the final incident, the claimant provided sworn firsthand testimony that he could not work because he was getting sick at work. As such, the claimant should be qualified for benefits and the employer's account should be protected from charge. Therefore, we should modify the AT decision: no misconduct, no chargeback, MBI.
Ms. Gonzalez, I would agree with Commissioner Demerson. No misconduct, no chargeback due to MBI.
Agreed.
We have a unanimous decision. Thank you.
Case number 2841669, Commissioner Alvarez.
The decision should be reversed. The employer was not following basic COVID safety protocols as recommended by the CDC. Coworkers were not wearing masks, and the claimant was not provided with gloves while working as a laundry attendant. The claimant spoke with the managers about the issue, was told that if she did not like it, she could leave. The employer has not provided any testimony or any other evidence that contradicts the claimant's testimony regarding the failure to implement COVID safety protocols. The employer's failures to address the claimant's legitimate concerns constituted good cause connected with the work for quitting. Reverse AT, no voluntary leaving, no overpayment.
We should affirm the appeal tribunal decision. The claimant had a complaint about her coworkers not following COVID safety protocols. When the claimant complained to her immediate supervisor, she was instructed to visit with him after her shift. Instead, the claimant walked off the job because a different supervisor was allegedly rude to her. By walking off the job while work was still available, the claimant initiated the job separation. Furthermore, by quitting before meeting with her supervisor as instructed and without providing the employer a reasonable opportunity to address her concerns, the claimant quit without good cause connected with work. Finally, since the disqualification is appropriate, the resulting overpayment is also appropriate. We should affirm the AT decision. Voluntary leaving, overpayment of $2,024.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent and memo to UI to investigate PUA eligibility.
I have your short form dissent, Commissioner Alvarez, and we will send a memo.
Thank you.
Case number 2854504, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant contacted the employer's sister clinic and thereafter informed its staff to dispense an unprescribed medication to a patient. When the claimant's supervising physician became aware of the claimant's conduct, the claimant alleged that the physician reprimanded her publicly in front of staff. To the contrary, the supervising physician provided sworn firsthand testimony that she did not yell at nor have heated arguments with her staff. She had counseled the claimant in private about the importance of maintaining patient safety. The physician's testimony was corroborated by the statement of another supervising physician at the employer's place of business. He detailed that the claimant had a history of performance issues. The claimant was also always brought in to the office to discuss potential concerns. After the final incident, the employer had attempted to contact the claimant multiple times about her possible return to work. The claimant did not get in touch with the employer. The greater weight of the evidence suggests that the employer did not engage in abusive and unwarranted reprimanding of the claimant. Furthermore, the claimant did not exhaust all available means to rectify her employment. Accordingly, we should reverse the appeal tribunal decision, voluntary leaving, no chargeback, adequate employer response.
The AT decision should be affirmed. On her last day, the claimant was reprimanded by her supervisor for an incident involving medication given to a patient. The claimant provided credible testimony that she did not authorize any change in the medication and that her supervisor reprimanded her publicly in an accusatory and unprofessional manner. The testimony from the parties was in conflict. The appeal tribunal was in the best position to assess the credibility of the witnesses and strength of the evidence, and the commission should not substitute its judgment for that provided by the appeal tribunal. The AT concluded that the claimant's testimony was more credible than that from the employer, and the commission should respect that assessment. We should therefore affirm the AT conclusion that the claimant quit the job with good cause connected with the work. Affirm the AT, no voluntary leaving, chargeback.
Affirm the AT, no voluntary leaving, chargeback.
Short form dissent.
I have your short form dissent, Commissioner Dimerson.
Case number 2874657, Commissioner Alvarez.
The decision should be modified. The claimant was living and working in Maryland. The claimant quit to move to Texas to be with his spouse, who was undergoing cancer treatment. Because the claimant quit to move with his spouse under these circumstances, the claimant should be qualified for more than 6 weeks. Modify the AT, quit to move with spouse, 6 weeks disqualification.
We should affirm the appeal tribunal decision. The claimant left his job in Maryland to return to Texas for his wife's surgery. No job separation occurred at that time because the employer allowed the claimant to work from home for 2 weeks. After that time, the claimant quit when he was unable to return to his job due to financial issues. Since the claimant quit for personal reasons, his quitting was without good cause connected with the work. We should affirm the AT decision, voluntary leaving.
Affirm the AT, voluntary leaving.
Short form dissent.
I have your short form dissent, Commissioner Alvarez.
Case number 2877643, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I agree the claim is valid. As to the job separation, the claimant was suspended after she drove a company vehicle into the employer's building. In her fact-finding statements, the claimant explained that as she was entering the employer's parking lot, a car was backing up, so she accelerated to avoid being hit. After that, she knew she needed to stop the car, but stepped on the gas instead of the brakes, thus hitting the building. The claimant's own statements established that she failed to use reasonable care while driving on the employer's premises, thereby damaging property and endangering the lives of patients. Accordingly, because the claimant's negligence jeopardized the life and property of others, she was discharged for misconduct connected with work. We should modify the AT decision. The claimant filed a valid claim, misconduct, no chargeback, sever the adequate response issue.
The decision is not supportable. The employer placed the claimant on an indefinite suspension without pay while they discussed her employment status. As the claimant was no longer working or being paid, she filed a valid claim. Regarding her separation, the employer suspended the claimant because of an accident in a company car. The claimant had swerved into a building to avoid hitting a client who pulled out into the parking lot. The employer has not provided sufficient evidence to dispute the claimant's testimony regarding the accident. Further, the claimant did not have the funds to take the drug test requested by the employer. The employer has failed to present sufficient evidence of misconduct. Modify the AT, valid claim, no misconduct, chargeback, void adequate response.
Modify the AT, valid claim, misconduct, no chargeback, sever adequate response.
Short form dissent.
I have your short form dissent, Commissioner Alvarez. That is the last of the pulled cases on docket 36. You should have already received a copy of the short form dissent list for the remaining cases on docket 36.
I move we accept staff recommendations on the remaining UI cases on docket 36.
Chairman, I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 36.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 36.
Motion passes with the exceptions noted. Thank you. Let's take a quick break. Get some folks in here for the rest of the meeting.
Thank you, guys.
Yeah. Let's come back with agenda item 8. This is TRS Mentor and Assessor Funding BCY 2022.
Good afternoon, Chairman Commissioners. Reagan Miller with Child Care and Early Learning. Today for your consideration is a discussion paper to distribute funding to support Texas Rising Star mentor and assessor staff through a distribution of $17 million to local workforce development boards. The distribution is based upon the number of Texas Rising Star and non-Texas Rising Star subsidy providers. As we move towards mandatory participation in Texas Rising Star as required by House Bill 2607, boards will be working with a larger number of child care programs. In addition, as boards implement the new Continuous Quality Improvement Process, or CQIP, mentors will be providing more robust coaching and assistance to help all Texas Rising Star programs. These increases are intended to help support both program growth and the more intensive CQIP. We're seeking your guidance on distributing the funds for board contract year 2022 as outlined in the attachment of the paper, and I'd be happy to answer any questions.
Comments or questions?
None here, Chairman.
None.
Is there a motion?
Chairman, I move that we approve the method for distribution of TRS mentor and assessor funding for board contract year 2022 as discussed by staff.
Second motion.
Been moved and seconded. We're unanimous.
Thank you.
Let's see, we don't have anything under agenda item 9. How about agenda item 10? Nothing under agenda item 10. Legislative report? Nope. Executive Director's report? We're on a roll. The time is now 1:33. The Texas Workforce Commission is now going into executive session in room 242 pursuant to Texas Government Code Section 5510711 concerning pending and/or contemplated litigation. Titled Benjamin Lafumba versus Texas Department of Criminal Justice, Texas Workforce Commission, cause number 19 CCV 066338.
Yeah, I think so. Surgery, he's gonna get employers. Okay. Less. It's less.
The executive session is now concluded. The time is 2:00. Do we have a motion?
Mr. Chairman, I'd like to move that we approve the filing of an appeal of the Fort Bend County District Court order and decision in the litigation styled as Benjamin Lafamba versus Texas Department of Criminal Justice and the Texas Workforce Commission, cause number 19-CCV 066338.
I second the motion. Is there any discussion?
None here, Chairman.
None.
Yeah, motion carries. Is there any other order of business come before the commission?
Chairman, we have a new employee in our office, James Andrew Bias. I know he went back to our office. He's our new executive assistant. I just wanted to welcome him on board.
All right, thank you.
Oh, and we're gonna have hot dogs in the office if anybody wants any
When?
right now.
All right.
Is there any other business? Hearing none, is there a motion to adjourn?
Chairman, I move that we adjourn.
Second?
Been moved, seconded to adjourn. We're adjourned.